Hello all, welcome you to the course on corporate laws and governance. In this video, we will be learning about the Director General and the National Company Law Appellate Tribunal. First, let's look at the powers, functions of the Director General. Director General is appointed by the Competition Commission of India in order to investigate the cases where the Competition Commission of India feels that there is a contravention of any rules and regulations of the Competition Act. These Director Generals are appointed under Section 16, subsection 1 of the Competition Act, and it also includes the appointment of any additional joint, deputy or assistant Director General. These Director Generals have all the powers as that of a civil court under the Code of Civil Procedure 1908 and Section 41, subsection 2 of the Competition Act mentions this. They have the similar power as it is enjoyed by the Competition Commission of India under Section 36, subsection 2. Here if we see, the Director General has the right to summon witness, they can collect the documents, they can look for evidences for the affidavits that are submitted. So, they have all the powers as that of the civil court in order to carry out the investigations. Now, let us see the procedural powers of Director General to investigate the cases. Section 26 of the Competition Act deals with the procedural powers that the Director General has. First, before the Director General starts with the investigation, the Competition Commission of India would form a prima facie opinion on the cases. They have to feel that a particular activity has anti-competitive nature or it has the potential to create an adverse effect on the competition. If the Competition Commission of India has this feeling that there could be a potential contravention of the rules and regulations, and once they form this prima facie opinion, they will instruct the Director General to go ahead with the investigation. So, the Secretary of the Competition Commission of India would be giving the information and the references along with all the relevant documents and other evidences that had been collected during the formation of the prima facie opinion to the Director General. Once the Director General receives these reports from the Secretary, it is the duty of the Director General to come with the investigation report within 60 days of receiving the information from the Secretary. In case the Director General thinks that he or she requires more time, they can always ask for the extra time, and it would be provided by the Competition Commission of India, provided they feel that it is required. Once this investigation report is ready, the Director General would be submitting the report to the Secretary. The Secretary should ensure that the report reaches the Competition Commission of India within 7 days from the date of submission by the Director General. When we look at the outcome of the investigation report, the outcome could be two things. One outcome could be that the Director General through the investigation might feel that there is no contravention of the rules and regulations of the Competition Act 2002. If they feel there is no contravention, then what the Director General would be doing is the Director General would be asking for any kind of suggestions or opposition from the opposition parties. If at all they have any kind of opposition to this verdict of no contravention, or if they have any suggestion to make to the verdict, the parties can come with their recommendations and objections. So, they will invite the objections and recommendation from the opposing parties, and they will be submitting the report along with any recommendation or objection that had been raised by the opposing parties. So, what the committee would be doing is, the Competition Commission of India would be doing is, the Competition Commission of India would be checking whether the verdict is correct, or they will be looking for the evidences, they will be checking the analysis, and they will come to a conclusion whether to agree the verdict that had been given by the Director General. Once they feel that there is no contravention, the Competition Commission of India can go with the outcome of the report. They can also affirm the decision of the Director General that there is no contravention. In case the Competition Commission of India feels that there is a contravention, in the sense they were not happy with the outcome, they can tell the Director General to further investigate into the matter. Similarly, when there is going to be a contravention, if the outcome is going to be a contravention of the rules and regulation, and if the Director General feels that way, again the Director General would be inviting the recommendations and objections from the opposing parties, and they would be submitting the report along with the objections and recommendations, and this would be submitted to the Competition Commission of India. Competition Commission of India again would be checking whether actually there is any contravention of the rules and regulation, what were all the evidences that had been presented, and what were all the analysis that had been done, and if they are happy with or satisfied with the outcome, with the verdict, they will go ahead with the verdict and do the necessary actions which they deem it fit. So, these are all the procedural powers of the Director General to investigate. Now, let us look at what are all the investigative powers that the Director General has, other than the going ahead with the investigation based on the prima facie opinion. The thing is that the Director General will start the investigation only based on receiving the prima facie opinion from the Competition Commission of India. They cannot do it suo moto. They cannot do on their own and start an investigation. That can never ever happen. The starting point comes only from the Competition Commission of India. They will form a prima facie opinion about certain transaction or an activity which they feel that could potentially result in anti-competitive behavior. If they feel, then they will instruct the Director General to go ahead with the investigation. So, that is the starting point of it. But during the investigation, if the Director General gets new information, then they can definitely investigate into the new information which they receive, which have not been told or mentioned in the prima facie opinion. We can understand this through the case between Excel Corporation Excel Crop Care Limited versus Competition Commission of India. In this case, if we look at the prima facie opinion, there was allegation by the Food Corporation of India, and the investigation was taken up by the Deputy the Director General based on the informant's allegation. But what happened during the course of investigation, the Director General also received information separately, not through the Competition Commission of India, through their prima facie opinion. They also received some information about the case from Food Corporation of India, and they took that also for investigation. When this matter was taken to the Supreme Court clearly told that the Director General has the power to look into the additional facts which would be submitted during the course of investigation. Not necessarily all the facts should come only through the prima facie opinion of the Competition Commission of India. Even during the investigation, if they are going to receive any kind of information or the facts, then they can take that up for investigation. So they have the power to do that. The next is to do with the addition of third parties. If we look at the case of Hyundai Motor India Limited versus the Competition Commission of India, in the prima facie opinion of the Competition Commission of India, there were only 3 car manufacturers. And when the Director General was conducting the investigation, they went for adding more manufacturers, automobile manufacturers, along with the 3 that had been mentioned in the prima facie opinion of the Competition Commission of India. So when this particular case went to the Madras High Court, Madras High Court made it very clear that the Director General added the other companies also, along with the 3 companies that had been mentioned in the prima facie opinion, after getting the approval from the Competition Commission of India, and their scope and power can be expanded if it is to do with the finding out of any kind of contravention of the rules and regulations of the Competition Act. They have every right to expand the scope and power during the investigation, though it was not mentioned in the prima facie opinion of the Competition Commission of India. Then if we look at a similar case, that is Cadila Healthcare Limited. So if we look at Cadila Healthcare Limited, in the prima facie opinion, the name of Cadila Healthcare Limited was not there, but when the Director General was conducting the investigation, they felt like Cadila Healthcare should also be involved or included in the investigation process, and this was actually affirmed. This decision was affirmed by the Delhi High Court. They felt that if the Director General feels that the names, new company names, have to be included for the investigative purposes in order to find out whether there is any potential contravention of the rules and regulation, then the Director General has the power to include the new company names that had not been mentioned in the prima facie opinion. Then let's look at the case of the Competition Commission of India and Grasim Industries Limited. If you look at this Grasim Industries Limited, if we in the beginning, the Competition Commission of India was actually asked the Director General to study only about any contravention of Section 3 of the Competition Act, which was to do with the anti-competitive agreement. But while investigating, the Director General found out that there could be contravention of Section 4 of the Competition Act, which is to do with the abuse of dominant position. So though in the prima facie opinion it was not told that there could be contravention of the abuse of, in the sense contravention of Section 4, which is to do with the abuse of dominant position, since the Director General felt during the investigation process that there could be misuse of the dominant position, so there is nothing wrong in the Director General in investigating about the other possible contraventions which could have happened, which they feel that could have happened. They can always include that. The scope can definitely be expanded. Next, let us look at the duties of the Director General. The first duty what the Director General has is to do with conducting investigations, because the very purpose of appointing the Director General is to do investigations on behalf of the Competition Commission. Once the Competition Commission feels that there could be a contravention of the rules and regulations of the Competition Act. So the main duty that the Director General has is to conduct investigations. So they have every right to summon the witnesses in order to conduct the investigations. The next duty what the Director General has is to gather evidence. So in order to prove that there is a possibility of anti-competitive behavior by the companies involved, the Director General has the duty to gather evidence. They have the power to collect documents. They have the power to analyze the document, and they can even ask for the evidence for the affidavits that are submitted. So, it is the next duty of the Director General is to gather evidence in order to prove that there could be the contravention of the rules and regulations of the Competition Act. Next, once they have gathered the evidence, analyzed the data, and analyzed the different reports that had been given by the witnesses, they will have to come with the report wherein they will have to clearly state what were the possible contravention on which they went ahead with the investigation, and they will have to mention what are all the evidences they have gathered during the investigation process and what are all the evidences that were supporting the possible contravention of the rules and regulations of the Competition Act, and they have to submit the report to the Competition Commission of India within 60 days from the date of receiving the information from the Competition Commission of India. So, they will have to prepare and submit it within 16 days to the Competition Commission of India. The next duty that the Director General has is to give expert opinion to the Competition Commission of India whenever the Competition Commission of India wants the opinion of the Director General on the competition laws, the policies, and the different government policies and their impact on the competition in India. So, on any of these things, when the Competition Commission of India requires any opinion, so it is the duty of the Director General to provide that expert opinion. Then the next duty of the Director General is to assist the Competition Commission of India right from the investigation, gathering the evidences, and even in the case of the technical duties as well as the administrative works. So, it is their duty to support the Competition Commission of India not only with respect to the investigation, but also to do with the administrative and other technical help should be extended to the Competition Commission of India. The next duty of the Director General is to take up the prosecution once the verdict has been given and approved by the Competition Commission of India. Once there is going to be a contravention and when the report has been submitted and it's been approved by the Competition Commission of India, it is the duty of the Director General to take it forward like prosecuting the offences. So, it is their duty to take this particular activity forward. The final duty of the Director General is to conduct advocacy. It is their duty to create awareness about the various provisions that are there in the Competition Act. They should ensure that the enterprises follow these rules and regulations in order to create a very healthy competitive environment. So, creating awareness among the suppliers, producers, distributors as well as the consumers with respect to the provisions of the Competition Acts and ensuring that all the stakeholders in the industry follow the rules and regulations. So, this is also one of the duties of the Director General. Next, let us move on to the Competition Appellate Tribunal. Till 2007, the Competition Commission of India did not have any appellate tribunal. So, once the Competition Commission of India comes with a verdict and in case the opposing party are not happy with the verdict, they have to appeal only to the Supreme Court. They did not have any other tribunal, appellate tribunal, wherein they can go and ask for redressal. So, what happens whenever the companies go to the Supreme Court, it takes time, in the sense the pendency case would be more. It would take more time for them to get their redressal. So, until 2007, if an opposing party is going to be unhappy with the verdict of the Competition Commission of India, they will have to go only to the Supreme Court. But after the amendment of the Competition Act in the year 2007, this Competition Appellate Tribunal was established. So, this Competition Appellate Tribunal was there whenever any opposing party were not happy with the verdict of the Competition Commission of India. What they tend to do is they will be appealing to the Competition Appellate Tribunal for the redressal. So, this Competition Appellate Tribunal was there until 2017. But what happened due to the different issues and difficulties that Compat and the CCA had, what happened was again the Competition Act was amended, and Competition Appellate Tribunal was merged with the National Company Law Appellate Tribunal. So, what happened was in the year 2017, Section 2, subsection BA as well as Section 53A of the Competition Act was amended, and various other provisions of the Competition Act dealing with the Competition Appellate Tribunal have been omitted, and which led to the replacement of the Competition Appellate Tribunal by the National Company Law Appellate Tribunal. So, the Competition Appellate Tribunal got merged with the National Company Law Appellate Tribunal in the year 2017. Competition Appellate Tribunal was there in existence and it was functioning as the Appellate Tribunal under the Competition Act from 2007 till 2017. If we look at the problem that the Compat and the Competition Commission of India had was, you can see from this particular table that if there were many, especially in 2013-14 as well as 15-16 and 16-17, we can see that nearly 44 cases were set aside by the Competition Appellate Tribunal. What do we mean by setting aside means if they feel that whatever order that the Competition Commission of India gave, it was not correct. If they feel so, what they will do, the verdict will go in favor of the companies. That is not the problem here. What happened was the Competition Appellate Tribunal directed the Competition Commission of India to reinvestigate the cases that it had set aside. We can see in the year 2013-14, 44 cases were set aside, and all the 44 cases were reinvestigated by the Competition Commission of India on the order of Competition Appellate Tribunal. The same is in the case of 2015-16, 87 cases were set aside by the Competition Appellate Tribunal. Of this 87, 67 cases had to be re-examined, had to be re-investigated by the Competition Commission of India. So, due to the different issues, this Compat got merged with the National Company Law Appellate Tribunal in the year 2017. And we can see the disposal rate of the cases both by the Competition Commission, the Competition Appellate Tribunal as well as by the National Company Law Appellate Tribunal. If you see here, the disposal of the cases had been actually increasing for Compat. It was at its highest when in the year 2016-17, nearly 74.8% of the cases got disposed. But we can see there is a dent in the disposal of cases post 2017, wherein the National Company Law Appellate Tribunal came into force. If you see here, National Company Law Appellate Tribunal is not there only for the Competition Act, but if we look at the Competition Appellate Tribunal, it was a standalone appellate body which was taking the appeals that was happening under the Competition Act only. But if we look at the case of National Company Law Appellate Tribunal, they act as the appellate tribunal to 3 different laws. So, any appeals that happens under the Companies Act 2013, any appeals that happens under the Insolvency and Bankruptcy Code 2016, and any appeals that happens under the Competition Act 2002, all the three appeal would go only to the National Company Law Appellate Tribunal. That is how this NCLAT is different from COMPAT, because Competition Appellate Tribunal was there only for the Competition Act, unlike the National Company Law Appellate Tribunal. So, let us look at the structure of the National Company Law Appellate Tribunal. We have a chairperson, and we have 3 judicial members and 2 technical members, and the age of the members, whether it is a chairperson or the members, it should be 50 or above. And the maximum number of members that the National Company Law Appellate Tribunal can have is 11. It can never exceed 11 members. If we look at the qualification that the judicial members should have is, the judicial members should have at least 5 years as district judge. They should have acted at least 5 years as a district judge or high court judge, or they should have a minimum of 10 years experience in the judicial authority capacity. If we look at the qualification that the technical members should have is, one qualification that is expected is, the technical members should be the secretary or the additional secretary to the central government, and they should also be a member of the Indian Corporate Law Service or the Indian Legal Service, and they should have a minimum of 15 years experience and more. And another qualification that is expected out of the technical members are, the technical members should be a chartered accountant or a cost accountant or a company secretary, and they should have the experience of 15 years or more in their relevant field. And all these members' age should be more than 50 or more. Now, let us look at the powers and functions of the National Company Law Appellate Tribunal. The National Company Law Appellate Tribunal can hear the appeals against the directives, orders and decisions of the Competition Commission of India under Section 2BA and Section 53A of the Competition Act 2002. Similarly, the National Company Law Appellate Tribunal has the powers to hear the appeals against the Insolvency and Bankruptcy Board of India under Section 211 of the Insolvency and Bankruptcy Code 2016. NCLAT has also got the power to hear the appeals against the National Financial Reporting Authority under Section 410 of the Companies Act 2013. Now, let us look at some of the cases that were handled by the National Company Law Appellate Tribunal. The first case which was handled by the National Company Law Appellate Tribunal was the cement cartel case. Here nearly 11 companies were said to have involved in the cartel arrangement with respect to the fixation of the prices, also with respect to limiting the production and the supply of cement. The Competition Commission of India in its investigation found out that there was a vertical anti-competitive arrangement, they had the horizontal anti-competitive arrangement wherein the 11 cement companies were involved in fixing the prices of the cement in such a way that they could charge a higher price because they came to an agreement in limiting the production and the supply of the cement. The National Company Law Appellate Tribunal looked into the appeal done by the cement companies and they verified the evidence that were submitted by the Director General, and what they found out was they checked the production data, price data and the supply data of the cement, and the National Company Law Appellate Tribunal was very much convinced that there were horizontal anti-competitive arrangement among the cement companies. So, the National Company Law Appellate Tribunal upheld the decision of the Competition Commission of India, as a result of which the cement companies had to pay a penalty of rupees 6,300 crores. With respect to the case on Hyundai Motors Limited, the Competition Commission of India came to the conclusion that the automobile company was involved in the vertical anti-competitive arrangement, like the tie-in arrangements as well as the resale price maintenance. But when the appeal was made by the defendant, what the National Company Law Appellate Tribunal felt was like there were no enough evidence to prove that the automobile company was involved in the tie-in arrangements or with respect to the resale price maintenance. So, the National Company Law Appellate Tribunal set aside the orders of the Competition Commission of India. Now, let us look at the case with respect to Eli Lilly. This was a landmark judgment because this particular case brought in more clarity with respect to the de minimis exemption. Eli Lilly actually what they contended with the National Company Law Appellate Tribunal was that the Competition Commission of India, when it was actually calculating the turnover and the assets to assess the exemption under de minimis principle, they took into account the turnover and the assets for the entire enterprise, and they were not checking only the assets and the turnover of the target division which actually got acquired. So, when NCLAT looked into this particular appeal, what they felt was like Eli Lilly was right in the sense that when the de minimis exemption got calculated in terms of assets and turnover, they have to look only at the target division or the company that gets acquired, not the entire enterprise assets and turnover. So, this brought in more clarity with respect to the exemptions under de minimis principle. Followed by this, the Ministry of Corporate Affairs came in with a notification to bring in more clarity with respect to the calculation of assets and turnover for de minimis exemption. The next case what we have is the Flipkart Private Limited. Here the informant, when gave the information to the Competition Commission of India, they had grievances with respect to the violation of section 3 as well as section 4 of the Competition Act. They felt there could be a possible misuse of dominance which is dealt by section 4 subsection 1 of the Competition Act, as well as there could be a possible anti-competitive agreement wherein section 3 subsection 1 of the Competition Act deals with that. But the Competition Commission of India, when they formed the prima facie opinion on this particular information, they directed the Director General to go ahead with checking only the section 3(1) violation. So, what happened? The informant went for an appeal, and the National Company Law Appellate Tribunal looked into the matter and instructed the Competition Commission of India to also look into the possible abuse of the dominant position by Flipkart. The last case that we are going to look at is the case between Amit Mittal and DLF. In this particular case, the informant felt that there were anti-competitive agreement, in the sense the agreements that the DLF had with the buyers were unfair, discriminatory, and the informant also alleged that there was a misuse of dominant position by DLF. But when the Director General, so this was the prima facie opinion, and as a result of which the Director General was directed by the Competition Commission of India to investigate in this particular line. After the investigation, the Director General came out with the result that, or the opinion that, there were misuse of dominance by DLF, as well as there were anti-competitive agreements. There were anti-competitive agreement which was unfair as well as discriminatory to the buyers. When this was submitted to the Competition Commission of India, the Competition Commission of India looked into it and asked the Director General to submit a supplementary report to this by re-investigating the matter. So, when this supplementary report was submitted through the re-investigation by the Director General, the result was totally opposite to that of the primary report. In the primary report, Director General mentioned that there was the contravention of the rules and regulation of the Competition Act, but the supplementary report was just the opposite of the primary report that was submitted. So, which told that there was no contravention of the rules and regulations of the Competition Act. So, the informant went for an appeal with the National Company Law Appellate Tribunal, and when the National Company Law Appellate Tribunal looked into the matter, they made a decision that the Competition Commission of India cannot ask the Director General to go for further investigation and submit a supplementary report when the verdict that was given by the Director General was the contravention of the rules and regulation. So, the whatever decision that the Competition Commission of India made based on the supplementary report stand to be void. So, this was also again one of the major decision of the National Company Law Appellate Tribunal. Thanks for listening.